Welcome to Lecture 2 in our series of lectures to prepare you for the MPRE. In our first lecture, we talked about the very basics of lawyer regulation, who regulates lawyers, talked about bar admissions, discipline, multi-state practice, and unauthorized practice. In this series, second lecture, we're going to talk about the basic fiduciary obligations that lawyers owe to their clients. And of course, as fiduciaries, lawyers owe that basic obligation of competence and diligence. They owe the basic obligation of confidentiality. And finally, the basic obligation of loyalty, the duty to avoid conflicts of interest. Let's take each one of those pillars of the lawyer-client relationship up in turn. So what topics are we going to deal with in this lecture under lawyer-client relationship? Well, we'll start out by talking about competence and diligence, of course, competence and diligence, but also talk a little bit about the basics of malpractice liability. And although it doesn't really fit here, but it's got to fit somewhere, we'll talk about trust accounting. After that, we'll deal with confidentiality, the basics under Rule 1.6 and the attorney-client privilege. We'll also deal with the work product doctrine. And then after that, we'll turn to the biggest topic here, which is loyalty, the obligation of loyalty and conflicts of interest, talk about concurrent conflicts, then former client conflicts and confidentiality, and then finish up with some miscellaneous conflict issues, conflicts relating to prospective clients and organizational clients, along with dealing with some of the consequences of lawyers who have conflicts and how lawyers can waive or get their clients informed consent to conflicts. Let's now turn to the basics of the lawyer-client obligation. First of all, how it is a lawyer gets into a lawyer-client relationship. Then we'll talk about fees, how a lawyer gets paid and what the limitations are on a lawyer getting paid. We'll talk about the communications obligation and the scope of a lawyer's relationship with her client, and then finish, at least this segment, by talking about how a lawyer withdraws from representation. The lawyer-client relationship. Well, the best place to start on this topic is at the beginning, as they say, by talking about how a lawyer-client relationship is created. Well, before anybody becomes a client, they start off by being a prospective client. As to those individuals who come to us but never wind up hiring us, either because they choose not to hire us or we choose not to accept them, we still have an obligation to protect the confidentiality of all of the information that they give us. And to the extent that we hold any of their property, we have got to exercise reasonable care in the safekeeping of that property. Also, we've got to exercise reasonable care in giving them legal advice. We can't just off the cuff say, oh, you don't have much of a claim, because that would be a violation of the minimal duty of competence that we owe to them. So we have to exercise reasonable care in what little legal advice we may give them, even if they don't become our clients. You could also become someone's lawyer by agreement. That's the way most people become lawyers. Agreements to become clients preferably should be in writing, but notice it says preferably. There's no absolute requirement of a written lawyer-client engagement agreement other than a contingent agreement, which of course has got to be in a signed writing. You can also become someone's lawyer by the client's reasonable reliance. That's what REL means right there in this. Client's reasonable reliance that you are going to be her lawyer if the client manifests the desire to enter into a lawyer-client relationship and you, the lawyer, don't clearly decline the relationship, then you can become someone's lawyer under those circumstances. You can also become someone's client by court appointment. You, of course, cannot seek to avoid the appointment of as someone's lawyer unless you have some good cause. What's good cause? Well, good cause could include that your representation would violate law or a rule, like for example a conflicts rule, or it would be an unreasonable financial burden. Also, if there's some impairing repugnance that you really hate this person and you could not represent him, then, and it would impair your ability, then you can seek to decline the court appointment. Fees, money. Of course, we're all called to the legal profession, but we want to get paid. What are the rules and the regulations that govern fees? Well, first of all, communication. You've got to tell the client before or reasonably after commencement of the lawyer-client relationship what the fee is going to be. If it's a contingent fee agreement, you've got to tell them in a signed writing. Signed writing. I can't emphasize that enough, that this is a signed writing that is required in order to enter into a contingent fee agreement. All right, the overarching principle is that all fees must be reasonable. And that's not just fees, but it's fees and expenses. How do you determine when a fee is reasonable? Well, you have to consider these non-exclusive factors that are all set forth in 1.5A. And of course, those rules, that rule talks about you have to consider the time and labor required for the matter, fairly obvious, how novel or difficult the matter is, the skill required to represent the client in the matter, whether it precludes other work. Obviously, if you've got to turn aside other work, then you can charge more. What time limits are imposed? Also, what fees and rates and percentages are customary in the locality, the stakes and the results. High stakes, you can charge more. Better results, you can charge more. Whether there's a prior relationship. That's a little odd, but if you've represented someone before, they're willing to pay you more because you're a known quantity and they don't have to pay more to avoid risk. And finally, whether or not there's any risk assumed by the lawyer. Then if the lawyer does assume risk, like in a contingent fee contract, the lawyer can charge more. Okay, now let's deal with contingent fees. We've already talked about, one of these basic requirements is that the contingent fee has got to be in a signed writing, but the other regulations are deal with, for example, you cannot have a contingent fee in a criminal case or in a domestic case if, not all domestic cases, but a domestic case where it's contingent on custody, child custody, or on the divorce. So don't think that this means that you can't ever take a contingent fee case in a domestic case. You can if it relates to property, not if it relates to kids or divorce. As to contingent fees, and we've already said this, I'm going to say it again, the client's got to agree to it in a signed writing. That signed writing has got to set forth how the fee is going to be calculated, the expenses to be deducted, and whether that fee is going to be calculated off the net amount recovered by the client after deduction of expenses or on the gross amount recovered before expenses. Now, I'll tell you, most lawyers are going to recover on the gross, but you just need to tell the client that. Fee collection practices, the lawyer has a charging lien on the proceeds, which means that a security interest attaches to the proceeds recovered by the lawyer. Lawyer has got to retain disputed funds in her trust account until the dispute is resolved. Fee splitting, can lawyers split fees? Well, they can't pay referral fees. You can't just pay your friend some money because she sent you a great personal injury case. But you can share fees with lawyers in your firm or lawyers outside of your firm if you comply with Rule 1.5E, which includes the total fee's got to be reasonable. It's either paid in proportion to the services provided or otherwise, as long as the lawyers both assume joint responsibility and the client agrees in writing, in a writing that discloses each lawyer's share. Also keep in mind that lawyers can have disclosed non-exclusive referral fee agreements. You don't really see those very often. They just have to be non-exclusive and disclosed to the client, and then they are okay. Okay, enough on fees. Let's turn from fees to communication. Rule 1.4 is the basic rule on communication, and it essentially says you've got to give your client all the information that your client needs in order to give informed consent to any matter that requires informed consent. Obviously, settlement offers are among the matters about which you must obtain your client's informed consent. You've got to communicate with your client about the status of the matter and the means of accomplishing your client's objectives. The client wants to see a copy of the petition. You obviously have to respond to reasonable requests for information from the client. You also have to tell the client when what they want is unethical. So you have to consult with your client when the client wants unethical assistance. The scope of the lawyer-client relationship. You may limit the scope of your relationship if the client gives informed consent. So you, for example, could say, I'm only going to handle your workers' comp case. I'm not going to handle any associated tort case against the manufacturer of a product, for example. That would be acceptable. You, of course, have to abide by the client's decision to settle the case, to plead guilty or not guilty, to waive a jury, to testify in a criminal case, and to appeal. Those are not your decisions, those are client decisions. Now, some things that are beyond the scope of a lawyer-client relationship, which again are fairly obvious. A lawyer cannot assist the client in a crime or a fraud, but you can discuss the consequences of a proposed course of conduct. Suppose the client says, I don't want to pay taxes. You can say, well, that's illegal. I can't help you do that, but I can tell you what may happen afterwards, and you can walk through those consequences. You can, of course, give assistance in violation of the rules of professional conduct. Fairly obvious. What about when you're dealing with a diminished capacity client? And this is all dealt with by Rule 1.14. And this is the overarching principle is that you've got to try to maintain a normal lawyer-client relationship. Now, having said that, what 1.14 then allows you to do is if there's a substantial risk of harm that your client is facing, a lawyer may can go out and take protective action, even though it looks as if he's working against his client's interests, and he can disclose confidential information, like, for example, to try to help the client because the client has diminished capacity. Now, if imminent and irreparable harm is looming, the lawyer can take action on behalf of the client, can actually start controlling the client's affairs. Now, that's not preferred. The lawyer really should only do that on a temporary basis to avoid that imminent and irreparable harm. Eventually, the lawyer needs to get somebody appointed, like a curator or a conservator, to take care of the client's needs. And the final issue on the kind of basics of the lawyer-client relationship, withdrawal. When must a lawyer withdraw? Well, if the client discharges the lawyer. And of course, clients can discharge us with or without cause. Does that mean we're out of luck as to money? No, we can still get quantum merit, which is a kind of an award out of fairness, but we've got to get off the case. We've got to get off the case if the lawyer is mentally impaired or physically impaired, or the representation would require a violation of other law or a rule of professional conduct, for example, if there's a conflict. Now that's the must, mandatory withdrawal. What about permissive withdrawal, the may, when you can stay on the case but you want off? And this is the simplest principle. You can get off for any reason if there would be no material adverse effect to your client's case. And that's the vast majority of cases when people want to get off, that it's going to be hard for the client, but it's not going to materially adversely affect the client. You could also, even if it's going to cause material adverse effect to your client, you can get off if the client persists in a crime or a fraud, if the client has used the lawyer's services for a past crime or a fraud, if the client is uncooperative or repugnant, or if staying on the case would cause a financial hardship on the lawyer, or the client breaks a promise to the lawyer, like to pay a fee. What are a lawyer's duties upon withdrawal? You got to give the client reasonable notice and time to get a new lawyer. And finally, you've got to return all unearned fees and the client's file and property. Fairly straightforward. And at that point, the lawyer's off the case, and the lawyer has satisfied her obligations to her now former client. Okay, now let's talk about competence and diligence. Rule 1.1, what do the rules require for a lawyer in order to be competent? Diligent, what does that mean? Does a lawyer have to work the client's files every single day? What is that obligation? And then finally, what are the elements of legal malpractice liability? Competence, rule 1.1, the number one rule in the very first substantive rule in the rules of professional conduct. Lawyer must be competent. What does that mean? Well, first of all, it means that the lawyer's got to have the legal knowledge and skill that's necessary for handling the client's matter. Now, you have to consider how complex and specialized it is. I mean, if the lawyer's never handled, for example, a uncontested divorce, it's not terribly complex and specialized, so even the antitrust lawyer can handle that. You can take a case if you've got lots of general experience, even if you haven't had experience with this particular type of case. You can look at the lawyer's training and experience in a particular field. If a lawyer has not a lot of background in this area of the law, but lots of time to prepare and study, well, then the lawyer very well may be able to undertake the matter. Lawyer, if he consults with other lawyers, might be able to take a matter that otherwise would be outside of his area of expertise. And finally, if there's an emergency, for example, if somebody needs to go to court to bail somebody out or to argue for release, under those emergency circumstances, it's more reasonable for a lawyer to undertake an unusual matter. So it's not just legal knowledge and skill, but lawyers, even if they're brilliant, they have to prepare. A lawyer who is brilliant and skilled but unprepared is a terrible lawyer. Preparation is an element of competence. And then finally, lawyers must maintain competence through continuing legal education programs as prescribed by the various regulators in their jurisdictions. Diligence. This really is just kind of a corollary of the Rule 1.1 obligation of competence. Lawyers have just got to do the work. Even if they're brilliant, even if they're well prepared, they have to move their cases along. Now, having said that, lawyers can be zealous, but they don't have to be uncivil. They've got to control their workload so they're not overwhelmed and having papers piled up in their offices. They've got to conclude matters promptly and then clarify the end of the lawyer-client relationship. And this says must. There's no rule that says a solo must have a succession plan in practice, but that's really something that a solo needs to do. Otherwise, his estate could be looking at malpractice liability for failure to deal with that. I would say that contingency. There's no contingency about dying. It's going to happen, and solos need to prepare for it. Trust accounting. Now, trust accounting doesn't really fit here in competence and diligence, but it's got to fit somewhere. It really is one of the things that gets lawyers into a lot of trouble, their failure to properly account for property of their clients. So what are the basic trust accounting obligations? They are these. First of all, when the lawyer gets funds belonging to a third person, usually the client, got to notify the client. Then the lawyer has got to segregate those funds. Put another way, the lawyer can't commingle those funds with her own funds. Having segregated and not commingled the funds, the lawyer needs to safeguard them, make sure that the lawyer doesn't lose them. The lawyer needs to deliver them, not steal them. That would be conversion, and that's a capital offense in the lawyer discipline system, disbarment. And finally, the lawyer's got to account to the client for the property. Basically tell the client when the property came in, from whom, on what date, what happened to it, and then what is being given to the client. So all lawyers who hold the funds of third persons, including their clients, need trust accounts. Generally, these trust accounts need to be the state in which they practice. Only client money can go in there unless the lawyer wants to put bank fees in there as well, just a minimal amount to cover bank fees. Individual accounts as opposed to pooled accounts. We'll talk about pooled accounts in just a second. Individual accounts are necessary if there is substantial interest to be earned, which is not often in a low interest rate environment. Pooled accounts, usually lawyers have what are known as IOLTA accounts, interest on lawyers' trust account accounts, where it's one single bank account at the bank. It's usually a commercial checking account, and into that one account goes the money of lots of different clients. And then the interest that's earned is paid to the bar foundation in the state and is used for various charitable and educational purposes. What funds go into the trust account? Advances on fees and costs, any funds in dispute, and any funds belonging to a third person. A lawyer's got to keep completed records for 5 years. Legal malpractice. Now, this is distinct from discipline. If you do something that is below the standard of care, you can be disciplined for it, like disbarred or suspended. But that's not what we're talking about here. We're talking about civil malpractice, which is just basic tort liability. And what this is all about is, it happens in a civil court, not in a disciplinary tribunal. It's just a tort case. The adversary is the injured plaintiff, not the Office of Disciplinary Counsel, and the purpose is to compensate the injured plaintiff, who was usually a client, former client of the lawyer, not to punish or protect the public. Now, suppose the lawyer has violated a rule. Is that relevant? Well, there's no presumption of malpractice just from a rule violation, and there's no malpractice per se. But if a rule violation reflects a breach of the applicable standard of care, and that breach has caused the plaintiff to suffer damages, then the rule violation is relevant on what the applicable standard of care is. And that's what this says. It says that the rule violation is relevant evidence regarding whether the lawyer's conduct fell below the standard of care, and actually more to the point, what that standard of care is. So when we're talking about malpractice, again, mal is just bad, malpractice. What theories of liability? Usually, almost always, you're talking about negligence, which is just a basic negligence case. So you have to prove what the duty of care is, usually by reference to the rules of conduct, that the lawyer breached the duty by performing in a substandard manner, that breach was a cause in fact and approximate cause of the client's damages. That's 90% of all malpractice cases. Having said that, sometimes you could have other theories of liability, like you could sue a lawyer for intentional tort or fraud or misrepresentation, abuse of process, conversion, for example, the lawyer steals trust monies, but these are rare. You could also sue a lawyer for breach of fiduciary duties of loyalty and confidentiality, and perhaps breach of contract. If the lawyer's promised a result and didn't deliver, you can sue the lawyer for breach of contract. Last issue related to competence and diligence and malpractice. A lawyer can limit prospective malpractice liability only if the client is independently represented by counsel. Now, I can't imagine many situations where this would actually happen, but for example, a lawyer might take a case in an area that she is really not familiar with, and the client's begging her to do it. Lawyer might take it as long as the client waives prospective malpractice liability. Suppose a lawyer has committed malpractice. Can the lawyer settle the malpractice claim with a client? Yes, but can't settle the claim with an unrepresented client unless the lawyer jumps through 2 hoops. Hoop 1, he advises the client in writing of the advisability of seeking independent counsel and gives the client time to consult that independent lawyer. Last point, malpractice insurance, not required. Oregon, at one point at least, required malpractice insurance. I'm not sure it still does, but it's not required. But of course, it is preferred. Confidentiality. What are the basic obligations, ethical obligations that lawyers have to keep matters confidential? What is the difference, and what exceptions are there to that basic obligation of confidentiality? And as you'll see, there are a whole host of exceptions. What are the other areas of law that regulate lawyer confidentiality? Rules of evidence, rules of procedure, and we'll talk about the attorney-client privilege and the work product doctrine to round out our discussion of this very basic fiduciary obligation of confidentiality. By confidentiality, what are we talking about? Well, what we were really talking about are two principal sources of law that impose this obligation. They are the ethics obligation, the Rule 1.6 obligation to keep matters secret, and the attorney-client privilege, which is a rule of evidence that gives lawyers the ability to refuse to answer questions, although they otherwise are compelled to respond to a subpoena. What's the relationship between these two sources? And this is really a source of confusion with many clients. Well, a good way to think about it is, think about the difference between gossip and compulsion. Rule 1.6 just essentially puts tape over your mouth, prohibits you from just going home or to a restaurant or cafe and gossiping about what happened. So it just tells you to keep your mouth shut about your client's affairs. The attorney-client privilege, however, prohibits compelled disclosure when you are subpoenaed to a deposition or to a trial. This gives you the ability to say, no, I'm not going to answer your questions. Remember, 1.6 can't do that because 1.6 is not a rule of evidence. Now, that's one difference. Another difference is the scope of the coverage. Rule 1.6 covers all information related to the representation. Rule 1.6 is very broad, and that's the big broad circle that's represented there. The attorney-client privilege, however, is a smaller subset of those in our Venn diagram. It only covers communications, right? Not all matters relating to the representation. So 1.6 is very broad, and the attorney-client privilege is a smaller subset of that information within Rule 1.6. Also, 1.6 regulates disclosure and use. The attorney-client privilege only deals with disclosure. So, it's important really to understand that these fundamental distinctions between the sources, and also to keep in mind this Venn diagram so you really can understand the relationship between those confidentiality obligations. All right, well, let's deal first with Rule 1.6. Rule 1.6, again, very broad obligation, and the rule says that a lawyer can't disclose information relating to the representation. Very broad. A lawyer also must make reasonable efforts to prevent inadvertent disclosures. That's a relatively recent amendment that was added in 2015. Exceptions. This is all found in Rule 1.6b, and it's a whole litany of exceptions where a lawyer may, but again, keep in mind, it's a permissive rule, 1.6b, where a lawyer may but need not disclose. Now, there are other rules that may require a lawyer disclose, but you're not going to find any required disclosures in 1.6b. These are all permissive disclosures. All right, well, what are they? First of all, and again, that's what this is all about, addresses only when disclosure is permitted, not when it's required. First of all, a lawyer can disclose information if it's generally known, if the client gives informed consent, if the lawyer has implied authority, like for example, the lawyer's got implied authority to go talk about his cases to try to settle them, for example. Lawyer can disclose information to prevent reasonably certain death or substantial bodily harm. Lawyer can disclose information to prevent financial harm if the client has committed or will commit a future crime or fraud, and it's reasonably certain that substantial financial harm will happen in the future, or if it's happened in the past, that the lawyer's disclosure will prevent or mitigate the harm, and the client has used the lawyer's services. Now, this is really important. Only applies, you can only rat out a client financial harm if the client has duped you into assisting in that crime or a fraud. And also keep in mind that some good's got to come from the disclosure. There's got to be some harm that will be prevented or mitigated in the future. Lawyers can just disclose confidences if there's a dispute regarding the lawyer's conduct. The lawyer's got to reveal on an as-needed basis, limited to those who need to know, and the lawyer's got to minimize the risk of harm to the client. Lawyer also can disclose confidences to obtain legal ethics advice, to comply with law or court order, and this is the permissive rule that allows many of the disclosures that are required in other rules. A lawyer may disclose to find conflicts upon an employment change. All right, now let's go to the attorney-client privilege, and we'll come back down to the work product doctrine in just a second. The attorney-client privilege. And the basic rule is up here. The rule is you cannot compel either a lawyer or a client to you can't compel them to disclose confidential communications between the lawyer and the client if the subject matter of the communication concerned the professional relationship between the lawyer and the client. What's a lawyer? That's what this is all about. A person authorized or reasonably believed to the client to be authorized, not acting in some other capacity like a friend or a father, and it includes the lawyer's agents like secretaries, paralegals, etc. All right, who's a client? Obviously a person seeking legal services, including prospective clients. So the attorney-client privilege doesn't just govern actual clients, but prospective clients as well. And corporate employees, if the communication is made at the direction of a superior, the purpose of the communication was to obtain legal advice for the corporation, and the subject of the communication was within the scope of the employee's duties. What is a communication? And again, all these terms, all we're doing is defining really this. So that's all we're doing here. A communication, of course, is obvious usually. Not pre-existing documents or things. So a document doesn't become privileged just because a lawyer touches it. In confidence, the communication's got to be done under circumstances where it was intended to be confidential, not something that was blurted out on an elevator, for example. And the standard is, was it made with a reasonable belief that no outsider would hear? A third party is okay if present to further the lawyer-client relationship, like a translator, for example. A couple of miscellaneous rules. The client, not the lawyer, holds the privilege and decides whether to waive it or to assert it. The lawyer, of course, has a duty to assert it. How long does it last? It's indefinite. It survives the term of the lawyer-client relationship and even the death of the client or the lawyer. There are exceptions that apply to the attorney-client rule, the attorney-client privilege, just like there are exceptions that apply to the Rule 1.6 rule of confidentiality. The crime-fraud exception is the big one. If the lawyer is consulted with a client for purposes of committing a crime or a fraud, then it's not a privileged communication. If the communication is relevant to the breach of duties arising out of the lawyer-client relationship, if it's civil litigation between persons who were joint clients of the lawyer, or if the lawyer furnishes evidence about the competency or intention of the client regarding the disposition of property by will or inter vivos transfer. And last, the work product doctrine. This is a rule of procedure that allows a party not to disclose information that's been prepared by the lawyer for litigation or in anticipation of litigation. There's no need to disclose such information unless there is a substantial need to do so, and the inability to gather that evidence from other sources would unduly hardship the other party, cause an undue hardship to the other party. And then finally, if we're talking about lawyers' mental impressions or opinions, that's really extraordinary work product, not ordinary work product, and that's rarely disclosed. There's got to be some extraordinary basis for it. which is almost never the case. Conflicts and the duty of loyalty. These are probably the most nettlesome issues that come up in the day-to-day practices of lawyers. What is the basic obligation of loyalty? What sorts of conflicts do lawyers face? We'll talk about concurrent conflicts. We'll talk about former client conflicts. We'll talk about prospective client conflicts. And we'll also talk about imputation of those conflicts. Finally, there are special rules that are designed to deal with particularly problematic situations that lawyers sometimes find themselves facing. For example, when they're doing business with a client or they are accepting a gift from a client, we'll talk about those particular rules that deal with certain concurrent conflicts arising in various practice settings. Concurrent conflicts of interest. This is the most common problem that lawyers perhaps face with regard to the duty of loyalty. And the rule is simple. The rule couldn't be simpler. It just says that a lawyer shall not represent a client if a concurrent conflict of interest exists. That's the basic rule in Rule 1.7. And the Rule 1.7 goes on to define what a concurrent conflict of interest is. And a concurrent conflict of interest exists either if there's direct adversity conflict or a material limitation conflict. So let's look at each in turn, starting first with direct adversity conflicts. Now, what does this mean? There's a conflict if the lawyer's clients are directly adverse to one another, whether the matters are related or unrelated. So, for example, a lawyer cannot sue one client on behalf of another and can't represent one client in a deal against another. So, for example, a lawyer, if you're representing me in my personal injury case against an insurance company, you can't just decide to represent my wife in a divorce case against me, even though it's completely unrelated. That would be a direct adversity conflict in violation of 1.7A1, and that would be a breach of your duty of loyalty to me. There are also material limitation conflicts. These are also concurrent conflicts of interest, and they exist whenever there is a significant risk that the lawyer's representation of one client would be materially impaired or materially limited by either the lawyer's personal interests or the lawyer's responsibility to another client, existing client, a former client, or a third person. So the conflicts would exist under all of those circumstances. What are some examples of material limitation conflicts where there's a significant risk that the lawyer's representation of a client is impaired by some other interest that the lawyer might be influenced by? Well, concurrent representation of criminal defendants. Remember, criminal defendants might want to shift blame from one to the other. They might have inconsistent defenses. They might have disparate culpability and different incentives for entering into plea deals, for example. Positional conflicts sometimes exist if a lawyer is impaired in his ability to take a position on behalf of one client because he's afraid how it might influence another client's case. A lawyer's personal interest. If a lawyer wants a job with an opponent or is related to an opponent or to an opposing lawyer, the lawyer might pull punches and not really whack the other side because of that concern for the feelings of someone else. Those are all situations where the lawyer's ability to represent his client would be impaired by some other concern that the lawyer has on his mind. All right, now some special rules. These special rules are all contained in Rule 1.8. It's a very long rule that just governs conflict situations that are so fraught with problems that the ABA decided that they needed special rules. And these special rules cover all of these situations. Now, in theory, they could be dealt with just by Rule 1.7, but that's theory. There are special rules that deal with each one of these situations. So let's take each one of them in turn. Sex. A lawyer may not initiate a sexual relationship with a client, You can turn a partner into a client, but you can't turn a client into a partner. Now, this conflict is not imputed to other members of the firm. So if you are having a relationship, your partner can still represent that client. Business transactions. You cannot enter into a business transaction with a client or acquire an adverse property or financial interest to that client unless the terms of the transaction are fair to the client and fully disclosed. The client is advised in writing of the lawyer's role in the transaction and that the client should get an independent counsel. And finally, the client has got to give informed consent in a signed writing. All three hoops must be jumped through, or else potentially the transaction is going to be subjected to nullification and the lawyer subjected to discipline. Use of client information. When can a lawyer use information? A lawyer may not use confidential information to a client's disadvantage unless he gets the informed consent. Now, if the lawyer knows that Home Depot is moving into a neighborhood, the lawyer can buy property across the street as long as Home Depot is not thinking about buying it when he represents Home Depot. That wouldn't disadvantage Home Depot, but he could not buy the land that Home Depot is seeking to buy, obviously, to benefit from that transaction. If the lawyer benefits from confidential information, may owe restitution to the client, even if no disadvantage. That's just under principles of agency law. Gifts to the lawyer. A lawyer cannot solicit or accept substantial gifts to himself or to a relative. Prepare an instrument that gives gifts to the himself or to a relative. And what does relative mean? Someone in the first or second degree or a close familial relationship. Media rights. A lawyer can acquire the story relating to a representation only after the matter concludes. You can't say, I'll take your case, but let me write a book about it. You might be more worried about the book than the case. You can talk about it afterwards. Financial assistance. Lawyers can generally not give financial assistance except litigation expenses. The lawyer can advance those litigation expenses and make repayment contingent on the outcome of the case. And for indigent clients, the lawyer can simply pay the costs the lawyer wishes to. Aggregate settlements. Suppose you represent 3 people who were all rear seat passengers in a taxi accident. You can represent all of them, and you can settle all their cases at the same time. However, you've got to disclose to all of them the total amount of the settlement, the existence and nature of all of their claims, the details of all of the client's participation in the settlement, including how much everybody's getting, how hurt everybody was, and all clients must give informed consent in a signed writing. Why require all this? Well, we want to make sure that we give all these clients full disclosure so that they can police the fairness of the settlement and make sure that the lawyer is not preferring one client to the other. We've already talked about this, but we'll say it one more time. Malpractice claims. A lawyer can get a prospective waiver of malpractice claims only if the client is independently represented. A client and a lawyer can settle a malpractice claims only if the lawyer advises the client in writing to seek independent legal advice and the lawyer gives client reasonable time to get that advice. Now, we've already talked about that, but there it is again. And finally, a lawyer cannot acquire a proprietary interest in litigation except that a lawyer can get a lawful contingent fee or get a lien on proceeds to secure her fee payment in the event that the client doesn't pay the bill. Former clients. The basic principle here is that lawyers owe their former clients residual duties of confidentiality and loyalty. Once it's over, your obligations aren't over. As to confidentiality, a lawyer has got to preserve the confidentiality of information. And a lawyer can't be adverse to a client if the information that the client gave to the lawyer during the former representation would be relevant to this new matter. As to loyalty, now, so, as to confidentiality, and sometimes I describe this on an XY axis with confidentiality over time, that confidentiality obligation never ceasing. From the beginning of the relationship to ever, it never, ever decreases at all. It is unwavering. Now, as to loyalty, however, the residual duty of loyalty that a lawyer owes to a client, that duty of loyalty starts at the beginning of the relationship, and it's strong during the relationship, but it drops down ever so much after the termination of the lawyer-client relationship. If this is the point of termination, then there is a diminished degree of loyalty that's owed to the client. That residual duty of loyalty is diminished to some extent. So that's what we're talking about here. And all it is that the lawyer cannot be materially adverse to a former client in either the same matter or a substantially related matter. That's it. As to unrelated matters, the lawyer can sue her former client on unrelated matters. Even as to matters where there is a problem, the affected clients can give informed consent confirmed in writing, and the lawyer can be adverse to her former client on the same or a substantially related matter. What about former firms? This is sometimes called the migratory lawyer issue, and this is the hypothetical right here. The lawyer moves from an old firm to a new firm. Do you disqualify the former or the new firm from the matter? Now, this can get kind of confusing. You got to follow along slowly on this and go through it carefully in your own mind. But let's focus first on the new firm. The new firm, where the lawyers just joined this firm, can't be materially adverse to a client of the lawyer's old firm if the former client of the new lawyer is a former client of the new lawyer, not just the new lawyer's old firm. This is 1.9a. So, for example, this lawyer actually worked on the case personally back at the old firm, and now he's at a new firm. He can't be adverse to that former client at the old firm on the same or a substantially related matter for all the reasons we talked about up here. Just a basic former client issue. Now, having said that, suppose the lawyer himself didn't work on the matter, but somebody else did in the office. If it's the same or substantially related matter, and the lawyer acquired confidential information relevant to the matter while at the old firm, sometimes known as water cooler knowledge, then the lawyer can't be adverse, can't do it, because the lawyer had acquired confidential information related to that matter while she was at the old firm. That water cooler knowledge disqualifies her new firm from representing a client adverse to that former client or client of the former firm. Now, it's okay to screen a disqualified lateral at a new firm. If the disqualified lawyer represented a client at a prior firm, the new firm screens the disqualified lawyer, and the new firm provides notice and certification to the former client. All right, now let's focus on the old firm. The lawyer has left. Can the old firm now be adverse to a former client of the lawyer who left and took that client? And here's the answer. Can't be materially adverse to the departed client if it's the same or a substantially related matter handled by the firm, and any lawyer remaining at the firm has confidential water cooler knowledge about the matter. Again, these are very similar standards. They sound similar, and they are. It's all about whether anybody's got water cooler knowledge. Now, of course, affected clients can give informed consent confirmed in writing and waive these conflicts. Government lawyer conflicts. And this is all the revolving door issue. It's all about the policy is we want to encourage people to go in government service and not disqualify them afterwards. And here's the hypo. The lawyer used to work for the government, now wants to be adverse to her prior agency. All right. Now let's talk about private work after government service. The government lawyer used to work for the IRS, now is off doing private tax work and wants to be adverse to the IRS. That's a good hypothetical. The former government lawyer can't represent a private client in a, quote, matter, close quote, in which the lawyer participated, quote, personally and substantially. And matter is defined by this rule to be, very narrowly, it's a particular matter involving specific parties. Is that conflict imputed? Yes, unless the lawyer is screened, the lawyer gets no share of the fee, and the agency gives written notice. Can this IRS lawyer, former IRS lawyer, use information learned at the IRS against private parties? Well, the short answer is no. The lawyer cannot be adverse to a person about whom he learned confidential government information if that information would disadvantage that person. Is this imputed? Yes, it's imputed unless the lawyer is screened and gets no share of the fee. Finally, government service after private work. Let's say you used to be a defense lawyer and now you want to be a DA because you're tired of the private practice. Ordinary conflict rules apply. You have to look at rules 1.7 and 1.9. So for example, you couldn't be adverse to a former client in the same or substantial related matter, but you could be adverse to them in an unrelated matter. Last issue on former relationships, former judges. A former judge can't represent a private client in a matter that he participated personally and substantially unless informed written consent is received from all the parties, and this is conflict is imputed to the firm unless the judge is screened and notice is given. As to law clerks, a law clerk has got to inform her judge before negotiating employment with a party or a lawyer for a party if the clerk is participating personally and substantially on the matter, not if her co-clerk is working on the matter, for example. And these rules also apply to arbitrators, mediators, etc. Okay, this is the last slide in our video number 2 on the lawyer-client relationship, competence, diligence, confidentiality, and loyalty. We are here going to deal with just a few miscellaneous conflicts. First of all, what are some of the consequences of entering into a conflicting interest representation? Well, if the conflict is apparent at the beginning, the lawyer's got to decline the representation. If it arises during the representation, the lawyer has got to withdraw. And if he doesn't withdraw, he could be involuntarily disqualified by the court. Of course, any conflict can lead to discipline or malpractice liability. Again, if there's resulting damage, there's no per se malpractice just because you undertook a conflicting interest representation. If that conflict manifests itself in the lawyer doing substandard work, and that substandard work causes damages to the client, well, then that conflict can lead to malpractice liability. Imputation of conflicts, incredibly important principle. Lawyers in a firm are treated as a single unit for conflicts purposes. If one lawyer in a firm has a conflict, all the lawyers in the firm have the conflict. And by firm, it's a traditional firm, but it also would include a corporate law department, public defender's office, etc. Now, there's an exception here. Personal interest conflicts are not imputed. So if a lawyer just personally couldn't handle a case for an abortion doctor, for example, that personal interest conflict is not imputed to all other lawyers in the firm. Many conflicts can be waived. Sometimes it's called informed consent, but most lawyers call them waiver. A client can waive or consent to a conflict if it's in fact consentable. That is, if a reasonable lawyer would conclude that the conflict would not impair his ability and there's no direct suit, one client suing another client in the same litigation. So assuming it's consentable, the client gives informed consent and the lawyer follows up the client's informed consent with a confirmatory writing, well then the lawyer can represent the client, notwithstanding the existence of a conflict of interest because of the informed consent. Third persons. What conflicts can arise from a third person? Well, compensation. If somebody's mother is paying you, then you might want to talk to the mother about the case, or you might do what the mother wants. So if you're receiving compensation from a third party, then there's a potential conflict. So the rule is a lawyer can't accept money from a third person unless the client gives informed consent confirmed in writing, the third party doesn't interfere with the lawyer's independence, and client confidential information is fully protected. And insurance is just an example of this. Lawyers typically represent insureds. There's always a possible conflict between the insurer and the insured. If there's a coverage dispute, if there's a settlement offer within limits that the client wants to take but the insurer doesn't, there's a conflict. So again, you got to be particularly sensitive to conflicts that might arise in the tripartite relationship between insured, lawyer, and insurance company. Prospective clients. What conflicts issues arise with regard to prospective clients who never become actual clients? Well, as to these people, the lawyer has got to preserve confidential information. If a guy comes to your office and says, "I killed my wife," you can't tell anybody. It's both privileged and it's confidential under Rule 1.18, which is the basic rule on prospective clients. That's the rule with regard to confidentiality. What's the rule with regard to conflicts? Well, you generally cannot be adverse to a prospective client in the same or substantially related matter if you have confidential information that could, quote, significantly harm the prospective client. If it's going to harm the prospective client a little bit, it's okay to take the matter. It's got to significantly harm the prospective client. You can get the prospective client to waive or consent to this, and there's no imputation of this conflict if the lawyer tried to avoid exposure to the confidential information. The lawyer is screened and doesn't share the fee, and written notice is given to the prospective client. Last topic with regard to conflicts, organizational clients. The starting point for this is that the lawyer represents the organization, not its constituents. And the lawyer's got to assure that the constituents understand that he's not their lawyer, he's the organization's lawyer. A lawyer may represent, of course, both the organization and its constituents if the lawyer gets, there's no conflict, and if there's a conflict waiver that's needed, he gets it from a non-represented constituent. There are times when a lawyer representing an organization finds out somebody in the organization's doing something wrong, and the lawyer's got an obligation then to report up the organizational chain of command, and sometimes to report out. Now, this is true both as an ethical matter under Rule 1.13, and it's also true under federal securities law, the Sarbanes-Oxley Act. Now, the Sarbanes-Oxley Act only applies to securities lawyers usually who are dealing with representing big companies. I've got all that information here, and these obligations are very similar to those that are found in 1.13. I've got them on your chart, but I doubt they're going to be tested. I'm not going to really talk about them any more than that, but you should just glance it over. But as to Rule 1.13, if a lawyer knows that a person is violating a duty to the organization or that's in violation of the law, and that violation may be imputed to the organization, and that violation is likely to cause substantial injury to the organization, then the lawyer must act in the best interest of the organization, must report up to the highest authority in the organization, and he's got to do so even if he's fired. And if he gets no relief, he may report out of the organization, blow the whistle, go to the regulators, or the police, if the lawyer reasonably believes it's necessary to prevent substantial injury to the organization. All right, so that's all I want to say about organizational clients and these miscellaneous conflicts issues. All right, well, that concludes our discussion of the basic fiduciary obligations of confidentiality, loyalty, and competence that lawyers owe to their clients. And as I said, this is our longest single lecture. Having talked about the basics of those obligations, we'll turn now in part 3 to the different obligations that arise in connection with the law or lawyering as a business.